Hello, and welcome to today's General Counsel's webinar series. Before I kick off today's webinar, I'd like to address a few housekeeping items. Today's webinar has pending CLE credits in Illinois and California. Credits are only available for today's live webinar and not on demand. If you need credits for additional states, please let us know. Please be sure to download your certificate after the webinar, as well as fill out the survey. Both are located at the bottom of your screen as an icon. You'll also be able to find the slides as a PDF, as well as additional resources, also located as an icon at the bottom of your screen. And now, it is my pleasure to introduce today's webinar, Analyzing Digital Breadcrumbs Evidence During Employee Disputes and Complex Investigations, presented by today's General Counsel and iDiscovery Solutions. Our distinguished speakers are Hunter McMahon, Director of Data Analytics for iDiscovery Solutions, and Aaron Cruz, Chief Data Analytics Officer from Littler Mendelson. Hunter?
Thanks, Jennifer. We're going to forego traditional introductions as both our bios are on websites and jump right into the topic. That said, I think it's worthwhile for Aaron to give a quick brief introduction to his new role at Littler, coming back and rejoining the team here.
Yeah, thanks, Hunter. Yeah, so I recently rejoined Littler Mendelson as a shareholder, but instead of sort of being front-facing and lawyering on a day-to-day level, I am responsible for building out or continuing to build out the data analytics and technology practice here at the firm.
So with that said, let's go ahead and jump into today's discussion. So as we've outlined for everybody in the registration page, a big part of what we're going to be talking about are digital breadcrumbs, right? The little pieces of information that you leave behind in all of your interactions with technology. I was at a conference not too long ago that we were talking about how even the concrete and freeways now have technology embedded in them. It's everywhere. There's a lot of information out there, and now how can we leverage it in the employment context, but overall in investigations and litigation. We welcome questions throughout it. We would rather have this as an interactive, and Jennifer will jump in and interrupt us when possible. But we're going to go through and we're going to show you some visualizations. We're going to show you some outline, and more importantly, we're going to give you a lot of case studies, some background, and some examples of how this can be applied in both single plaintiff, single employee, and large groups, large class actions, and low budget, high budget. So we'll jump in. Let's talk about data, Aaron. It's in both of our titles. What does data mean to you insofar as when you're looking at an employment matter, what kind of sources are we talking about?
So I actually think that this is a really important point right out of the box. The data that we look at really depends on the kind of question that we're trying to answer, right? I mean, the interesting thing about the modern digital world is everything you do, more or less, from the minute you go to bed to or rather the minute you wake up to the minute you go to bed, and sometimes even there in between, if you have like a smart bed or your smartphone next to you or whatever, you're kicking off data. And so depending on what we're trying to understand, right, in terms of a fact pattern or what's happened historically, we're looking for various types of data that are going to answer specific questions. So if I want to know, what time Hunter got up this morning, I'm probably going to want to take a look at, his mobile phone, because he probably set an alarm at some point last night, and he probably got up. He probably started sending emails at some point this morning. He got on a phone call at some point this morning, right? I can literally start to recreate big pieces of his day as soon as I have access to data and understand what question I'm trying to answer.
So that brings up a point. We'll talk about that throughout the webinar today, as it'll be a common theme. How do we know what questions we're trying to answer up front? I mean, that's an important aspect of analyzing any kind of data, is going into it with a question rather than going into it with an answer, or worse, not knowing what you're even looking at. So how do you start framing that early on?
So I think, it really, particularly in legal, it's not that hard, right? We're used to framing questions. I mean, if an employee leaves and there's a question of, did that employee take sensitive information? Well, there's your question. Did that employee take sensitive information? And if so, what did they take, right? We can start to then drill down into specific questions that sort of, when answered, give us the answer to the greater question. But it's literally taking a step back and literally formulating what is it that we are trying to understand. And once you've formulated what it is that you're trying to understand, the questions that you're trying to answer become relatively obvious, I think.
So I often get the pushback of, well, this doesn't apply to me, and we don't have that information, or, our employees don't use that, or, all of those kind of, well, push it off, right? Data's hard to get to, it's expensive and whatnot. But it's amazing what people are using in their day-to-day lives to generate this kind of recreation of what they've done. So we've got a video here, and this is of Thanksgiving last year, of a little turkey trot that I did in our neighborhood. And by adding my pictures through this app, it actually uses the embedded information of the pictures to know when to put those pictures associated with the run, where to put them in the run, and recreate this map. It's called Relive. They actually launched it during the Tour de France. But it's an amazing little app that we can now use on an individual basis. But this same kind of recreation is what is happening when we're looking into investigations. So it's happened in other cases, right? It's been used in criminal cases. Here we've got a man that was claiming that an intruder came into his house and assaulted his wife, and he and his wife, and it turns out the Fitbit told a different story. The wife was still alive when the supposed intrusion happened. So how do we start using even the personal devices, though, and where do we start drawing a line on personal devices, or is there a line when you're running these investigations?
So from my vantage, again, it goes back to what we're trying to understand, right? Once you have a conception of what you're trying to understand, one of the immediate questions you should ask is what data sources are out there that might speak to this, right? If I'm trying to understand, for instance, did a person commit a murder, then anything that's a data source that is going to correlate to that person and their activities is going to be really important, right? And some of it I may be able to get, some of it I may not. But understanding what the options are lets me kind of drill in and start to identify data that I'd want to look at. So, Fitbit's a good option. There are, in criminal context, there have been cases where, people are subpoenaing Alexa data from the Amazon cloud because they want to hear what people said in the 3-second snippets that Alexa is constantly downloading, right? There's a divorce case that's relatively well known where an iWatch, the fitness app on an iWatch, is what gave the philandering spouse away, right? The philandering spouse had their husband or wife had access to, because they were sharing their health information back and forth, or their iWatch information, and he sees spikes, in the middle of the night when his wife was gone. Fascinating piece of information, right, that correlates to some interesting possibilities. So it's really about understanding the kind of digital exhaust or digital breadcrumbs that get thrown off all day, every day, and then sort of bringing those together in a way where we can analyze it in order to understand and tell a story.
Let's talk about the goals of an employee investigation, though, right? A common investigation that we run into is theft of trade secrets, theft of protected information, or even you think there's misconduct in the workplace. And we don't always have the ability to say, hey, Aaron, would you cooperate with us and give us your iWatch so that we can investigate what you're doing and where you are in the office? Or it's a personal device and they don't want to give it up. What type and where do you start on investigations from a digital breadcrumbs perspective to then start justifying further action, right? You're not going to get everything up front. So how do you start that process?
So my general rule of thumb, and this is with everything, is we start with the best, most reasonably accessible data that will answer the questions that we're asking. So, for instance, in an employee theft investigation, right, there's a bunch of stuff we can look at, but the obvious places to start is with the employer's own data that may shed light on it. So logs around internet activity, showing what sites they connected to. Are they connecting to their personal email? And if they are connecting to their personal email, is that abnormal compared to how they've operated for the last 6 months? Looking at security logs around the office itself, like did they randomly start coming in the middle of the night? call logs, right, that point us to with whom they're communicating and when. Information in their own emails. What are they kind of accessing, talking about? Who are they emailing, and what are they emailing to those people? Similar, if you have other communication like Jabber, Slack, you can look at that kind of information pretty easily. And then if you think about some of the other stuff that is out there, anytime somebody's accessing files across servers, right, there are logs there that we can look at, and we can literally look and see what are people accessing when. As you start to layer these various pieces of data together, what you start to see is literally a map, if you will, of the behavior that is reflected in that data, and you can start to correlate it to time and known events. And if you can start to do that, then you can start to tell a story. And if I can see that, hey, Aaron's leaving the company, he randomly, in the 2 days before he gave notice that he was leaving, he started sending a bunch of stuff to his personal email address. He started reaching out and touching file servers and pulling particularly sensitive information. And he started calling, the guy who is the head of the competitor company to whom he's going. I've at least got the beginnings of a case where maybe I have the ability to ask for and get some more information that may not be readily available within the company. It's literally starting to build the case, starting to understand, is there enough here to keep going, or are we essentially at a place where the answer is it doesn't look like anything bad happened, we're just going to cool our heels and see how it goes.
So there's a big lesson there that you just went through, which is you don't always get the smoking gun. You don't always get the answer in the first pass, but it's rather an iterative process that you have to be prepared to work through. So one of the analogies that I use is it's like the LA freeway system, right? In the South, where I live now, you could go 10, 15 miles without an exit. And that poses a certain level of problem. If you suddenly have to refuel or you have to get more gas, you have to be prepared for that. Contrary to that, though, in LA, there's an exit off that freeway every mile and a half. So more like LA, if you prepare your analysis, if you prepare your approach in the way that allows you to say, okay, we're done here, or we want to change freeways, right? LA has how many freeways? A ridiculous amount, but it allows you to say, okay, we've got to shift directions here. We're no longer on the right path. We need to change our goals. So part of going through the assessments, going through the investigation, is understanding your goals, but also understanding how to change and update your goals. So we have another example here of where an individual's story was not lining up with data, right? We have a pacemaker where we've got investigators were told that he woke up in the middle of a fire and climbed out of the window. And you would expect, if I woke up in the middle of a fire, my heart rate was going to go up, right?
I got ice in my veins. I'd be fine.
Yeah, you wouldn't burn through the fire. You would simply stand there and scare the fire. So if we're looking at that, though, we're saying, okay, what would be an anomaly here? And I think that that's the key when we're looking at data, right? We're looking for trends and we're looking for patterns, but we're also looking for anomalies. So if we're going through an analysis and say, what should we be seeing here? We should see an abnormal or a spike in heart rate, not a steady, nice, and easy, okay, I'm going to walk out the front door and then I'm going to set my house on fire. That's what we're looking for even in employee investigations, right? Where you gave the example earlier is suddenly doing something or suddenly not doing something. Sometimes the lack of activity is indicative that either they've changed their typical behavior, maybe they're using something different that we need to look at or need to at least consider, or we have the increased activity, which is generally pretty relevant. One of the key things to understand when we talk about increase of activity is it's not always a bad thing, and you still have to ask your question, why is that happening? So we'll run through some of these examples and some different visualizations. Now here, it's an analysis to say, okay, over the last 12 weeks, how many emails with attachments did somebody send? Because we want to know, is there a sudden spike? And here we can see that, about 3 weeks before their departure, there was a sudden spike. So what could that be indicative of?
So that could be indicative of a whole bunch of things. That could be indicative of them essentially saying goodbye to people, right? Starting to have a conversation about leaving. It could be indicative of, any number of things, right? Which is where you start to dig in to what's the actual content of the stuff that's in the anomaly, right? And I think that has to be part of this conversation is, any sort of spike, right? What it's really doing when you're looking at things like trend analysis, which is kind of what this is here. The deviations from the trend are what indicate you should go and take a look at the content of information that's in that deviation. So here, if you see the spike in emails with attachments that comes out of nowhere, essentially, we're going to want to go and take a look because it may be, maybe somebody drafted a kind of one-page going away, thanks for everything, you guys are amazing, and here are all the people I want to call out for being great. That happens. Alternatively, maybe they're sending emails to their house or to their new employer that contain all of your most important and sensitive trade secrets.
So here's kind of the next iteration of that, right? So it's not just a single angle that we have to look at when we're going through these types of analysis, but rather multiple. Here we've got another example, but this is a breakdown of internal, external, and personal domains. And we can see on that same week where a lot of attachments were sent, a lot of emails were sent to a personal domain. Highly suspect. From your perspective, Aaron, and with case teams, though, is this we exclusively look at that and we take that in and of itself as actionable, or does this now act as a map for where you want to go review substance, where you want to go review the content of those emails before jumping to conclusions?
Yeah, it's the latter for sure. Trade secret litigation is notorious for people kind of running off half-cocked to court and demanding, TROs and cease and desist and a whole bunch of other nonsense, and only to have kind of the case fall apart down the road. The far better play is to look at this set of anomalies and see, okay, in what is essentially stack 3, right? 3 weeks ago, you have a large jump in personal email, right, being sent out, and you also actually have kind of an interesting stack of external, right? So here, what you're going to go grab is you're going to go grab at least a sample of the stuff that's going to the personal domain. Depending on how big it is, you might grab all of it. You also want to look at that external, and then you're going to want to take probably a sample of the internal stuff to see what they're talking about. And that, again, it lets you ask and answer some questions. Is there something here? Does this look to be nefarious? Do we need to keep looking? If we need to keep looking, what should we move to next in terms of data sets that might further drive in and give us some more information?
So a point of clarification on the personal domains these are originating within the client's infrastructure and going to a personal domain. So we're looking at their sent email. We're not going into their personal emails and grabbing stuff or anything like that. That would pose a few problems. Yeah,
it'd be hugely problematic. So what you're talking about getting is the emails that they sent to themselves that are resident on the employer's server, right? The emails that I sent from my Littler address to my aaron@aaronisawesome.com email.
Which does not exist.
Which does not exist.
It would be a false statement. False advertising right there. So let's kind of keep going down the privacy path, right? And we had a question pop up as how do you get the pacemaker data? That was a criminal case, so you have a little bit different standards as far as investigations and subpoenas that the government can get. But even in an employment context, let's say, for example, we catch this. We say, okay, now all of a sudden we realize you're sending data to your personal email. You now have your personal email. We don't know what else exists, and we don't know where it traversed from your personal email further, right? Because maybe I sent the client list from my corporate computer to my personal email, and then I sent it from my personal email to my new job's email, and now I want to go trace that. What process and at what point can you start going after those, and how do you go after that to add as a data source a layer into your investigation, because now you're in litigation?
Yes, there are a bunch of options there, right? And this is kind of an interesting and thorny thicket depending on what you're looking for. But the long and short of it is if I have enough information to be able to make at least a prima facie case that Hunter took something that's particularly sensitive, then what I can do is a couple of things. I can make an informal demand, essentially saying, hey, if you don't give us some peace of mind by letting us review or letting our expert review what's going on, then I have no choice but to bring legal action. If you've brought legal action already against people because there's enough information for you to do that, there's enough of evidence of potential wrongdoing that you've got a basis for bringing a colorable claim, then you would go through the normal discovery process, right? So in this situation, and a couple of things here, people often run off firing off subpoenas for information related to either social media accounts or personal email accounts or whatever. There's this federal statute called the Stored Communications Act, which gets in the way of those. And there's actually some very robust case law on why doing that is a no-no. But you actually have a couple of vehicles for it, right? What you can do is you can demand that stuff in litigation in normal discovery. You can say, I need access. I want to do an inspection. You may have to go to court and show the court the evidence that you have that says that that's in good faith and that's warranted. But it's a very doable thing. The place people get in trouble here is, like I said, either they fire off subpoenas to the actual service providers, and the answer you get back is going to be no, and a citation to the Stored Communications Act. Or alternatively, they, without kind of having evidence that would justify it, they fire off demands for give me every email you've ever sent, et cetera, right? It's taking a targeted, conservative approach that's backed by evidence that leads to the best results.
So as we transition, and we see this a lot, right, we see a couple of different flavors. One is we look at an employee, a departed employee, and we got nothing, right? There's no indicators of compromise. As you put it, we cool our heels, we move on, because there's nothing that's low-hanging fruit that says, yes, they clearly took something. Sometimes it's that critical player that walked out of their company building with the laptop and was trying to steal it. Okay, we want to look deeper right away. But on an average employee departure, you kind of do a litmus test and say, should we look further or not? If we don't, case closed, matter resolved. But what if we do? And then the transition of the analysis, from our experience, it's kind of a lull in analysis until we get more data. But then you cannot forego, and we see this sometimes, is clients say, okay, great, we had an analysis here. Now we have a new analysis. We're going to run that independently as opposed to kind of joining up the investigation with the litigation. How do you help clients and case teams work through that says we have to continue this analysis and layer in the data as opposed to kind of start a whole new bucket because now it's litigation?
Yeah, I mean, and this is a strategic decision, right? I mean, sometimes people have done an investigation and they want to protect the privilege around it, so they basically redo. I mean, there's a lot of reasons why you might separate them. But if you can take the fruits of the investigation, right, and you can take that analysis and use that analysis as the basis for the additional data sources that you are requesting, you're going to get a lot further, a lot faster, because you can show that you have a good faith basis and you're being reasonable in your request. It's not that you're asking for all their email logs because you're just throwing out this omnibus overbroad request. It's because, hey, I have significant evidence that shows that Hunter sent, using his corporate email, sent sensitive company-owned information to his personal email. I need to understand what's happened with that once it's in the personal email. What has he done with it? Has he accessed it? Did he send it to himself and never open them? I've seen it happen, right, where people were sending themselves stuff all the time. They never open it. At that point, you probably don't have a significant problem. You kind of have that stuff forensically removed from the account, so it's gone and can't be recovered. Move on. Alternatively, they forward it. They not only do they open it, they open the attachment, they save it to their local hard drive, and then they send it to themselves at their new employer. There you've got a bigger case. So the ability to take, and this is what's actually very cool about data analytics, right, is you can do analysis on multiple types of data, and as you layer that analysis together, you get a clearer and clearer picture of what sort of activities took place, when did they take place, And if you take that and layer communication content into the activities, you suddenly have not only the communication content, but the factual and action-based context in which those communications were made.
So let's take a look at an example of an analysis that we've done before, is what we refer to as the day in the life. And if we click through this, we see how we can layer, and we've done it, that you layer information on top of each other. So here we have a computer. User logged in, user logged out, presumably for lunch, user logs back in, their final day, right? Now we want to see USB activity. Okay, well that's interesting. They plugged in a USB on their last day. Okay, let's keep going. Now, cloud usage. Well, that's a little bit concerning, right? Now all of a sudden we see that they're visiting Google Drive on their last day. So far they plugged in a flash drive. They've accessed cloud storage. What about file activity? Now we're looking at this and saying, okay, well, they've got a good amount of file activity their last day. We can see that towards the end of the day, everything dwindles. They stop doing a lot of work, which is fairly typical. That's unless they're trying to offload the entire server. But normally, last day, the activity kind of dwindles. Personal emails, well, okay, so now we've got more indicators. We're saying, okay, now we've got personal emails. Again, this is from the corporate side, knowing that it's going to the domain. Social media activity. So this looks like they got bored for a little bit. You can see the lack of file activity and lack of other activity, and they started going on Facebook. They must have been updating their LinkedIn profile to try to, make sure that they were good to go. And then now we've got another one, that corporate email activity. So we expect to see corporate email activity. Now, one of the things we've got to make sure that we've got is all of those actions in a supporting format. The graph is great, and it helps you understand what happened. They clearly took a lunch break in the middle of the day, or presumably, and they were gone by about 4:30. Understanding where things went, how it went, now we can look, and as an example, we put in there, they were accessing the client list. Here's the USB device that they plugged in. Here's where they accessed the client list, and here's where they saved the client list and the Google Drive address that they visited. None of this individually is necessarily as powerful as all of it together. When we're looking at this, though, one of the key aspects that we've seen a couple of times, clients, we've got to interview on this final day anybody that interacted with that employee, because one of the big issues that we've seen is HR or somebody else taking a copy of the file. So those final activities, you've got to make sure, even though it's under the user profile, that it was actually the user. So even beyond these points of information that are coming from corporate systems, there's still a human aspect that you've got to layer on this that says, okay, well, we see the user log in. What you didn't know, and in this scenario, that user actually left before lunch. Everything else here was corporate HR that had launched the computer, they got into the user's profile, and they were doing stuff. They were sending emails, they were forwarding some things. Now, there's a whole bunch of problems that happened here and why HR was using that, but one of the criticals is to understand who's actually sitting at the computer when this is happening.
Yeah, I can't tell you the number of cases where it's internal people who are essentially, or maybe their assistant, right? Their assistant, maybe after they leave the building for the last time, their assistant goes in and begins kicking stuff to their successor, right? Because you have like important business whatever, right, that needs to be carried on. The activity could look really, really suspect if you don't realize who's actually driving the machine. And this is the interesting thing about this is data can tell you where you should go and what questions you should ask. Data can tell you, for instance, that person left for the day, right? Because, for instance, if I leave the garage in my building, I have to sign out. That might be another data piece that, was Aaron even here? And talking to people is part of that. Witness interviews are really crucial. The law, particularly modern law, is mostly a practice of understanding data and then talking to people so that you have the complete context around facts.
So let's talk about that, though, right? So we've got this model, and it's a fairly well-known model, DIKW, which is there's a transition from data to information to knowledge to wisdom. So I recrafted kind of the explanation of each one of these is when you have the raw data, it's the Google Drive, right? That's the web address, raw data. When you have information, you say the user visited Google Drive. Knowledge would be the former employee visited Google Drive right before he abruptly walked out the door. Interesting. Wisdom is knowing what to do then.
Right.
So that's, it takes, and I think you mentioned it earlier, I like using the phrase actionable intelligence. You can't simply look at the data points and say, well, I mean, access to Google Drive is in and of itself actionable, but the context around that, so there's additional data points that have to network within that data point to be able to support an action, or a call to action, if you will. Jennifer, do you want to go ahead and read the CLE code?
Absolutely. Thanks, guys. I'll only take up about 30 seconds. For those of you who are looking for CLE credits that need a specific code to attach, I'm going to read the code, I'm going to spell the code, and then I'm going to read the code, so please get your pencils. Today's CLE code is Breadcrumbs 27. That's BREADCRUMBS 27. Breadcrumbs 27. Okay, guys, back to you.
Thanks, Jennifer. We're going to transition a bit from individual employee investigations and go into more wage and hour and what are typically treated as a class action and go to a bigger picture. So how do we start assessing not one, but many employees and some of that? So one of the points of reference we like to give clients is the myth of average. And it's a great TED Talk. Highly recommend you go to it. We've included the link here. It's fairly old. I think it's a couple of years old, but it's absolutely spot on when it comes to collective actions. One of the issues that he brings out, and the way it comes out, is actually the military tried to design a cockpit or a pilot seat that would fit everybody. So they took all the averages of every pilot in the military that said, okay, you know, you're 5'2", he's 6 foot, he's 6'2", he's 5'9", and said, okay, on average, here is the precise dimensions of a pilot seat that should be in the cockpit. Unfortunately, 0 pilots actually fit that profile, so the seat was of no use. With information now and the increased presence of data, how important is it to start diving into not necessarily individual analysis in that you're looking at an individual employee each time, but rather a collective analysis to understand the individual profiles?
Yeah, I mean, it's crucial, right? Because average, the concept of average is a construct, right? It's not anything that actually exists in the real world. If you know, what is the average person? That's fake. So it's actually understanding, when we're talking about average and statistics in general, we're talking about whatever we're looking at, be they people, be they pilots, whatever, where do they fall on a curve, right? So you're going and particularly in things like wage and hour class action, what you often have is a group of folks, named plaintiffs, who profess to be representative of the rest of the folks on whose behalf they are suing, right, or have brought the action. And one of the kind of key analyses you can do is not only how well do those plaintiffs line up with the rest of the professed group, right, but how do the constituent members of the group line up with each other. These are like really important, really crucial ways of attacking kind of the allegations that are brought in these kinds of class cases. And the concept of average is really sort of important. As soon as you understand that it's literally a mental construct, you can actually start to figure out how is the most beneficial way to begin to parse apart the individuals who are sort of loaded into this particular class.
So part of it is understanding potential violations or potential failures in claims or supporting claims, because there are often within actions, there are valid claims in there that we need to be able to understand and assess the value of and not simply ignore saying that it was going to be defeated. One of the ways we've done it in the past is a heat matrix, right? So we can actually sit there and start to understand. Here's an example of one where we were looking for different type of activity, and against the claim, how many violations of that activity or how many occurrences of that activity did these individuals have within a day, a week, a month, or a year over the course of the period. And so here's an example of one where it lists out some of the employees, and it shows on a weekly basis how many. So we've got a couple big numbers in there, but then we also have a lot of small numbers. And guide crews is definitely one we on a defense side want to take a look at, and we on the plaintiff side don't want to put a lot of weight on, right? Actually, the information is intelligent, if you will. It's actionable for both sides. It's not one-sided. It is the facts, and if the data supports it. Drilling into one of these, though, what if we looked at an individual? So we looked at an individual's before and after hours activity. We see this a lot with wage and hour. Oh, well, they emailed all night. They were constantly on call. Not disputing that, but how often and how impactful was that actually during a scenario? So can we drill into somebody, and if you go back to the prior slide, you can look and see, okay, well, we know we want to hone in on somebody. Now, how often did this happen? And you can actually start noticing anomalies and trends that, okay, yes, for a month, this employee worked a lot of overtime, if that's the claim, and a lot of after-hours work because of responding from emails or making phone calls or whatever it is. But it was only 1 month. It was not the entire 3-year period.
You can also start to see things like it was for 1 month, and then you drill into the actual data for that person, and you realize that a lot of the email that was being sent that falls into the actionable group, quote unquote, is personal stuff, that they actually weren't working, right? Yeah, for a month they sent on average 100 after hours emails a night, but when you dig into it and only 2 of those are work related, and that work is only occurring in a single month out of a 3-year period or whatever, right? Now we're starting to have a very detailed, very nuanced discussion around what potential liability and risk looks like so that we can help people understand it and make strategic decisions. And in the people we're trying to help understand, I'm including the other side, right, plaintiffs' lawyers.
It's critical, though, right? I mean, I think that the analysis reveals the truth. I mean, and there's certain levels of how much data do we have and how much context do we have to be able to say how certain we know this is the whole picture, but it helps everybody understand. And arguably it helps everybody understand who are the real members of this action, who were wronged, if you will, that need to be paid, and who are not, and who are kind of along for the free ride. I had a friend who got the notice to potentially opt in to a class action, and he calls me and says, hey, should I opt in? I said, well, were you wrong? Do you have a grievance? Do you think that you actually need to be made whole? And he said, no, I thought that everything was okay. I was like, well, then why would you opt in? And it kind of got his wheels turning insofar as, okay, I don't have a problem here. Why would I get money for it, free money, if you will? But that's not exactly everybody. And so this kind of analysis starts to help fleshing out a lot of that information with the support of content, right, to validate. So we're going to go through and show you an example of another opportunity where GPS was used. And this was a lot of corporate data. GPS was used to rebuild some employees' lives to be able to analyze and understand what they were doing during the day. So,
and importantly, this is GPS taken from corporate vehicles.
Correct.
So the company owned the information that's being used.
So here we go. We've got... so everybody is aware, this is completely anonymized. So we've recreated the scenario in a different town and with different data points. But the spirit is there. Is here we've got a field technician that goes to different work sites to service an appliance, and we've got his house. So he starts at his house in the morning, and then he goes to his first stop, and then he goes to his second stop, and he goes to his third stop, and his fourth stop, and his fifth stop throughout the day. And we know that based off of other information, such as where he logged in and how he was logging his work through invoices, this is what it should have been. This is the routes he was supposed to take. This is the information that was supposed to happen. Not so much. So
the thing about it is, what you're seeing is what was reported versus what is reality, right? And when you look at what's reported, it's I went to these 6 service calls and I did the work and here's where I drove and here's the hours I worked. When you look at reality, what you actually see is a radical divergence from that.
So let's take a look at reality. Day starts, oh, we're going to go drop off the wife at the train station instead of going straight to the first site. Go to the second site, third site, not so interested. I'm going to go fishing for a couple of hours. Then I'm going to go to the third site, then the fourth site, then the fifth site. Go to the sixth, oh wait, no, I got to go to the driving range. I really like my golf game, got to improve that. Then I'm going to go to my final site and then go home. So when we ran the calculations, the original claim was 10.7. When you reduce by all of the personal detours and personal time off, he actually worked less than a whole day. So that went from 10.7, potential overtime, everything else, to less than full time. We need to talk about performance reviews at this level, right? And when we ran this analysis, there were individuals that absolutely were working and GPS and their data all lined up. So it's not okay, everybody has a problem all the time, but it does help validate those that do have opportunities there or do have claims there. So let's flip back. We want to make sure we wrap up at about 10 till so that we can give the opportunity for questions. But let's talk back, and we've talked through a lot of scenarios. We talked a lot about how we can layer it in. But when we talk about value of data, how do we know what is out there? What is easy? How do we get those layers in an organized and a beneficial workflow for a client? Like, how do you take that approach?
Yeah, so I mean, I'm a firm believer that you have to start a matter by going slow so you can later go fast. So sitting down and actually spending the time to come up with a plan, to outline the kinds of data that are likely to at least give you an idea, right, of where you should be looking and what the lay of the land looks like. So the way I like to think about it is high-level data that we can look at that will establish trends and anomalies, and obviously relevant information that we need to drill into for either content or pattern purposes. And then once we've taken a look at that, what we see there will drive us to the next phase. So you have to think of it iteratively, and you have to be planning from the beginning and taking the information that you are getting from these analysis and rolling that into your plan as you're building it.
So it's certainly changing the way things are litigated, right? I mean, you came back to Littler, and that's a big part of your initiative here, which is leveraging data and information to benefit clients. That could be whether it's looking at litigation overall, it's whether or not it's looking at a specific litigation, a specific instance, or what have you. But there's a lot of information out there. And we talk about market disruption. We talk about how things are changing. And there's some examples on the screen now of where it's changed in the past. And a colleague of mine always likes to point these out and say, Amazon, that until recently never had a storefront. You've got the search engine. You've got one of the biggest transportation companies don't own cars. This kind of transformation, though, of getting away from a traditional approach, taking a different, more investigative kind of a massaging the world of information as opposed to a brute force of information, it's unnerving to many. But how do they start understanding it?
I mean, so part of it is, I think you have to be curious. You have to dive into sort of what is out there in the world, right? You have to understand how does a mobile phone work? What kind of information is it collecting and throwing off? When people use apps, what kind of information are those collecting and throwing off? I'm a big believer that modern lawyers need to be playing with technology relatively often so that they're familiar with it, how it works. Once you understand kind of, Facebook, for instance, once you understand the kind of activity that goes on Facebook, you can think pretty quickly, what kinds of information might shed light on things I'm trying to understand? And as you start to do that, right, I think that's really that fundamental process. Is be curious, play with technology, start to try and understand how it works and what people do within that technology. Once you understand that, I can tell you, pretty much as a rule, if you're putting information out there, it's being recorded. If you know that it's out there and it's being recorded, and you can figure out a path to get it if you can show that it's relevant and potentially probative.
So 2 quick points to piggyback off of that is when we start with a client, we want to see the systems, right? I mean, we're very familiar with databases. We're very familiar with computers and forensics and everything else. But one of the big problems, or not a problem, a unique challenge, is how is the user actually using the system? How in an HRIS system or human resources system and time clock systems, how are they actually using the coding? How are they delineating fields? And there's a lot of customization that happens intentionally. Then there's a lot of customization that happens unintentionally just because that's how somebody started using it one day. So one of the things we found even with working with clients with known systems, it's almost a demo. Let's sit down with the person that knows that system and take a look. How would you do this? Asking some just very basic questions, and it seems very elementary on many cases, but it reveals a lot of information as to how we can actually leverage the information for the context as opposed to simply going back and saying, assuming a date field means this. I mean, that's usually one of the biggest mistakes we see is, date fields and actions that say one thing from a data point, but actually have been used a different way.
Right. The custodial interview is one of your best friends when you're dealing with corporate level systems.
So let's go through this real quick and we'll wrap up for questions, but we talked about defining the goals early and often. Who can help understand the data, which is kind of what I just walked through. What data sources, we talked about that, going for the corporate control, the easy, low-level, or lower-hanging fruit, if you will. Have you seen any trends, though, especially with the migration to the, quote, cloud, that you have less folks internally that can help you with that and you have to call outside experts?
It depends, right? It really depends on the organization. I think a lot of organizations, as they shift to the cloud, your logging is still there. Your IT group can still get you base levels of information. They can still get you content information, for instance, email. Email in Office 365 from a user standpoint is really functionally no different than email on a server that you have kind of in your basement or bathroom or back room or whatever. So functionally, no. Some of the things, as information moves to the cloud, some of the traditional methods for engaging an investigation, for instance, some of the traditional forensics tools and forensics processes that we would go through to try and understand what people were doing, that becomes unavailable because you don't have access to the physical devices. And it means you have to sort of rethink it and maybe look for other forms of information going forward.
Which kind of wraps us up from where is the data? But is earlier always better with data, or is it timing? I mean, in our experience, or at least in my experience, certain iterations, we've used that word a lot of times, several times today, having all the data up front is not necessarily as helpful because sometimes you can do what you need with 2 sources, 3 sources, 4 sources, and you don't need 10. So making that strategic decision of layering in on a progressive basis as opposed to all at once.
Yeah, I agree. I mean, the problem with lots and lots and lots of data, especially if most of it is useless or irrelevant, is that you can lose the important breadcrumbs, right, in a stack of breadcrumbs. The way I like to think about it, though, is the goal should be to acquire all of the necessary relevant information to make the strategic decisions that are necessary as quickly as possible. And that's true if we're in an investigative scenario. That's true if we're in a litigation scenario. We don't need to have every piece of relevant information, particularly in a digital world. That's a fiction. And we don't need to have sort of all of the information. What we need is all of the necessary relevant information so that we are essentially educated in the decisions that we're making.
So with that, we're right at 10 minutes. I think timing, we did well. Jennifer, do we have some questions that you want to throw our way, or we'll open it up to the audience and encourage questions at the very least.
We have two that came in earlier about leaving a work computer open early and the pacemaker data. I think you guys both addressed those.
We did. I do see one with
Okay.
regards to what happens if an employee leaves, but leaves their, we'll call it Gmail, their personal email and or social media, logged in on their computer.
Yeah,
Right.
The general rule is absolutely unequivocally do not let your people go strolling through it. It's problematic in lots and lots of ways. In fact, a good rule of thumb is you should leave things as they sit and not go gallivanting through people's systems. It tends to make a mess out of the forensics. It can give rise to individual claims for privacy violations. It's problematic in multiple ways. And in fact, one of the ways that you see people get in trouble in this space is a manager of a departed employee who's trying to do the right thing. It's nothing nefarious, but they do go in and they access, because it's on a machine and it's logged in permanently, an individual's private email or an individual's private social media page or whatever, and they kind of go through just to make sure that nothing's wrong, right? It's hugely problematic. Set it aside. Go through an actual process. It's your best advice.
Okay. I have another one. When investigating using social media sites, do any of them show the employee who has visited them?
Yes, and you can see that in a couple of different ways. So the social media site itself will have login records for the most part. If it's a system that they have to log into, there'll be a system log of some kind. It may not be retained for long, but it will be there showing that they logged into an account. The other place that you can see that, though, is on the corporate side of things. So in order to get to that social media account, that employee had to transit the corporate firewall. And so there should be an activity log within IT, right, standard data protection kind of logs that would show the activity that, Aaron Cruz went to LinkedIn at 10:53 in the morning on, January 18th.
So we've done it ways, and we've seen the claims of, oh, that wasn't me that posted that. But to Aaron's point, there are additional data points that can help support, no, that was actually you, right? The computer of origin, the mobile device of origin, we see that a lot. Well, I didn't have my phone with me, it was somebody else. And we can, okay, who was it? And then we start looking in the other directions to disprove the opportunity. So, okay, you said it, I claim that it wasn't me that posted on Facebook, it was Aaron because I left my phone there. Well, it turns out, no, it wasn't, because Aaron was on his phone doing something else and he was on, what have you. So you can start proving the negative around the positive to then get back to it as to whom was actually on that social media site.
And there may be other ways that you can do it too. Embedded metadata, particularly if it's something like a photograph, right? It may exist on only one device. There are lots of ways that you can kind of look at it. And that tends to be very fact-specific. What are you trying to understand, what are you trying to prove is really crucial to figuring out what you need to look at.
Okay, we have another one. Have you successfully sought text message screenshots? And can they be recovered from the ISP if the users have deleted them?
So I'll take one crack at this and then let Aaron go to the ISP question. So when we go to the mobile devices, there are multiple ways and avenues that we'll collect the information. We don't do screenshots. We always do a forensic acquisition of the device, which can be as minimal as logical acquisition of that device using forensic software or down to a physical acquisition. Then we run an extraction protocol because all of those text messages live in a database, not in a screenshot per se. So we want to get that information out from the storage component on that phone. And then we can recreate, in many instances, what appears to be a conversation view. That way it kind of looks more like a thread, if you will, if you were scrolling through the phone. And on a lot of devices, and we've seen a ton of them, deleted messages are not actually deleted, right? They can remove them from the user's view. They show as deleted, but they remain in the repositories. So getting that device itself is critical. The other avenue of opportunity for text messages or chat messages would be any of your backups. Particularly with iOS devices, a lot of folks have iCloud enabled and they have it backing up to iCloud. They don't remember or they don't think to go delete all of their backups from iCloud, so you can go after those backups and get some information. They synchronize it with the computer. That used to be more popular, where they were synchronizing music to the computer, but now everything is over iCloud for the most part, so we see less of that today than we used to probably 3-4 years ago. But going to the device has been very successful on the quote deleted. But Aaron, you want to opine on ISP?
Yeah, I mean, so the short answer is ISPs, not your friend. They tend to, if they keep them at all, they keep them for really, really short periods of time. Most of the time those messages, the content of the messages, are only resident on the devices. Now, the ISP will have a log of when text messages were sent to or from specific numbers. And sometimes that can be incredibly helpful because, let's say, I ask Hunter for text messages because I have a reason to believe he's engaged in something that's problematic. Hunter says, I'm not giving it to you. I can't get content of communications because of the Stored Communications Act, but what I might be able to subpoena in a legal action is the log of what time text messages were sent to a specific number or between a specific set of numbers in order to show that, yes, indeed, text messages were sent there, and that might give me the grounds for going to a court and seeking production of Hunter's text messages that are resident on the phone. And to Hunter's point, that content that's resident on the phone, text messages exist in a database. That database tends to be size rather than time delimited. So when you delete a text message, all it does is it masks it from the user. It continues to exist inside the database until the database grows beyond its allotted size, in which case it's first in, first out. So the oldest messages are going to be the ones that are overwritten first. And then as you progress in time with more and more text messages, you're going to start to see those purge out. But typically they're there for a long period of time.
The only addition that I would add to that is sometimes with different software updates that come through and different backups or restorations that happen, it will purge what is marked as deleted. So it's not a fail-safe that the deleted are all there, but you've got to look into the history of the phone, the entire history as to what iOS or what operating system upgrades have been applied and all of that. The next question, okay. Jennifer, I'm going to jump in and try to answer these in a little rapid fire. We've got about 2 minutes. Is what tools are you help you mine data, shape large data sets? We favor SQL, Elasticsearch. There are a couple other ones out there. We use large database tools and visualization tools to be able to replicate that. The one suggestion or the one caveat that I'll add to that is you need to have the traceability back to the original evidence. A lot of analysis can happen, and then you have a great end product, but you have to be able to go back to the original data points. Otherwise, you've got an evidence problem. The next one is it appropriate to track employees' movements in their company-provided phones? Do you have to have a notice, or can you do it secretly?
So your best rule of thumb, the legal requirements around notice, etc., is going to vary dramatically by jurisdiction, right? State and local. I mean, that's a Pandora's box of issues. I will tell you, generally speaking, your best way of dealing with things is to be upfront about it and have a policy so that people have a sort of a reasonable set of expectations about what you're doing to them and with them.
And then we've got if an employer pays for the internet services on an employee's personal device, does that give ownership over the internet activity?
Again, that's going to vary widely based on jurisdiction. But from an ISP standpoint, whoever owns, meaning whoever signs up for the account, is the quote-unquote owner most of the time. So whoever, my Facebook account, whether I am accessing it through an employer-provided internet connection or not, it's going to be mine.
Jennifer, that wraps up the top of the hour. I know there are a couple questions that are outstanding, but we'd be happy to answer those via email and follow up with those individuals.
Okay, perfect. Well, I want to say thank you to both Aaron and Hunter. This was a great webinar, and have a great rest of your afternoon.
Thanks, Jennifer.